1116943 in the matter of Harry Louis Najum.
May it please the court, Stan Hazelwood appearing for the Disciplinary Administrator's Office. I would request to reserve 2 minutes for rebuttal, please.
2 minutes is granted.
This disciplinary hearing occurred on September 29th of 2016. The respondent was present on that day with his counsel, Craig Schultz. The case really involves two components. The respondent's plea of guilty in federal court to a Class D felony, structuring a transaction to evade reporting. As a result of that conviction, the respondent has been temporarily suspended by this court since May 15th of 2015. Second component of the case has to do with the judge's finding at the sentencing hearing in the underlying felony case that the respondent knew that $16,500 in cash that he received from a man named Johnson, who actually was an undercover agent, that the respondent knew that that money came and was generated from unlawful conduct. The judge at the sentencing hearing made that finding by a preponderance of the evidence. The underlying conduct arose out of an undercover operation by the federal government involving the sale of large amounts or quantities of untaxed cigarettes in the state of New York. The respondent provided legal services to the undercover agent in that case, an individual named Bill Johnson, or as the undercover agent, his name was Bill Johnson. He also represented a local Wichita businessman as well. There was no question that the respondent received $16,500 in cash from Bill Johnson at some point in time. Actually, it was in June of 2011 for attorney's fees from Bill Johnson in cash. The underlying conviction arose as a result of the fact that the respondent did not tell his law firm at that time of the receipt of this cash. Consequently, the firm failed to report the cash transaction and file a report with the Financial Crimes Enforcement Network. The panel found that there was a violation of 8.4b. Because of the felony conviction, that rule states that it adversely reflects on his honesty, trustworthiness, and fitness as a lawyer because of the criminal conviction. And the panel found, as did the trial judge in the case, that the respondent knew that the $16,500 came from unlawful activity. And actually, the main reason we're here today is because the respondent adamantly contests the fact that he had knowledge that this money came from unlawful activity. The panel found that the respondent's repeated denials that he knew the funds came from unlawful activity was an aggravating factor in terms of its assessment of discipline, recommendation of discipline. In fact, the recommendations were as follows. The panel recommended a 3-year suspension. Two of the panel members recommended a 3-year suspension with no reinstatement hearing at the end of that time. But they recommended that the suspension begin at the date of this court's opinion. Third member would have required a 219 hearing. The respondent recommended a 2-year suspension retroactive to the date of the temporary suspension, May 15th of 2015. My recommendation is conditioned upon the finding or lack of finding by this court as to whether or not the respondent knew that the money came from unlawful activity. I said if the court finds that the respondent had knowledge that the $16,500 came from unlawful activity, it should be indefinite suspension from the date of the temporary suspension. If not, then I would recommend that the suspension be made retroactive to the date that the respondent actually was temporarily suspended.
Could you repeat that again?
My recommendation.
The first recommendation, if we find that he had knowledge, it's indefinite suspension as of the temporary suspension or as of the date of our opinion?
If you find he had knowledge, it would be indefinite suspension from the date of your opinion.
Of the opinion.
If you find that he did not have knowledge, it would be indefinite suspension from the date of the temporary suspension.
Okay.
The respondent filed exceptions. Briefs were filed. The first issue in this case was whether or not the panel properly applied Supreme Court Rule 202. And here we're talking about the judge's finding at the sentencing hearing by a preponderance of the evidence that the respondent knew that $16,500 came from unlawful activity. There were many of these conversations, most of these conversations between the respondent and the undercover agent were part of were recorded, and there were just a whole bunch of transcripts. So the relevant section of Supreme Court Rule 202 is, and I'll read it to you, all other civil judgments shall be prima facie evidence of the findings made therein and shall raise a presumption as to their validity. So we're talking about Judge Wimes, the judge in the criminal case, making this finding by preponderance of the evidence, not by beyond a reasonable doubt, but by a preponderance of the evidence after a sentencing hearing.
But
That the
what
respondent
do we
knew
do with,
the, I'm sorry.
I'm sorry. What do we do with the language about civil judgment?
And that's the first issue raised by the respondent.
I mean, it seems like very plain language, and I don't know how we ignore that.
You know, my position on that is that I think that that language is inserted in the rule to ensure that there is a finding made by a preponderance of the evidence. And I know it says a civil judgment, but that is, in my mind, to protect the respondent, to make sure that there is at least a finding by a preponderance of the evidence. To me, there was a finding by the judge, specifically in the transcript hearing, in the transcript of the sentencing hearing, and I believe that even though it says a civil judgment, I'm not exactly sure what you would term the sentencing portion of a hearing in a criminal case where the respondent has already pled guilty. But I think that the respondent is protected by the fact that there was a finding by preponderance of the evidence. That is if you look at it that way. But the way I look at it, because if you read the panel report, the panel found that the respondent's failure to acknowledge the fact that the $16,500 came from unlawful activity was an aggravating factor, not a separate finding of attorney misconduct. And this court has addressed that situation, the differences in the burden of proof when we're talking about a finding of attorney misconduct versus a finding an aggravating factor. And you said in the case of In re Hall at 304 Kansas 999 that unlike the standard for proving attorney misconduct, the panel does not need clear and convincing evidence to consider aggravating and mitigating factors. And under those circumstances, I think that the finding made by the panel that this failure to acknowledge that he received the funds knowing that they were generated from unlawful activity is an aggravating factor, not a separate finding of attorney misconduct, which would require, I think, the burden shifting. There's plenty of evidence in the record to support this finding, regardless. First of all, you have to realize that the pre-sentence investigator, this is part of the record, pre-sentence investigator, the prosecutor in the criminal case, the judge in the criminal case, and the panel in this case, all found that they believe that the respondent had knowledge of the unlawful activity. Clear and convincing evidence does exist within the record that Mr. Johnson told the respondent on numerous occasions that he was involved in illegal activity. You can see that from reading the transcripts. There's clear and convincing evidence that Mr. Johnson hired the respondent to provide legal services for him, and there's clear and convincing evidence that he received $16,500 in cash from Mr. Johnson. The second issue I want to address is the respondent's assertion that the panel committed error by not allowing Jack Foch's testimony as an expert witness. The respondent's position there is that he was denied the opportunity to properly represent himself or defend himself, that Mr. Foch's testimony would be that there was no information on those recorded conversations which would really lead a reasonable lawyer to believe that that $16,500 came from unlawful activity or from an illegal source. The expert testimony should not be excluded because it embraces the ultimate issue, in fact, and that the panel relied exclusively on cherry-picked portions of those transcripts in its government sentencing memorandum, and that Jack Foch's testimony would have explained those conversations. First of all, let me say that expert testimony, according to this court in the case of Sturba versus Jay, found at 249 Kansas 270, it states it will be of special help. The expert testimony needs to be of special help to the fact finder on the technical subjects with which the fact finder is not familiar. Special here is the key word. I mean, this panel, composed of two members of the Board of Discipline of Attorneys, Jeff Chubb and Catherine Marsh, and a third member, Art Palmer, who was on that board for a number of years. They had the knowledge, requisite knowledge, to go ahead and be able to make these determinations without the benefit of expert testimony. The panel's job in this case was really to look at the unlawful conduct issue and determine whether or not the respondent's testimony was credible on that issue. And that's not an issue that's not something that I believe that an expert witness should be able to testify about.
Mr. Hazlitt, I'm sorry to interrupt. If this were a legal malpractice case, I mean, it strikes me that this is the kind of expert testimony that comes in routinely in other kinds of cases. Should a reasonable lawyer have known this or that? And so I guess my question is, do you think this proffered testimony would be admissible in a legal malpractice case?
No, I view testimony that might be given in a legal malpractice case. It's not so much about the knowledge of the respondent, but whether or not it rose to the level, or his conduct rose, or her conduct rose to the level of malpractice or negligence. But to me, it's a separate issue when they say, essentially what they're saying is, we want an expert witness to come in here and tell you what Mr. Najim was thinking during this process. And that just, to me, seems inappropriate for...
But wasn't it framed more in the traditional language of whether a reasonable lawyer should have known? I understand the point you're making, that there may be some gray area there or bleed over, and a witness can't testify as to what the respondent's state of mind was. But why couldn't the witness testify as to what a reasonable lawyer should have known in these circumstances?
Well, again, I don't know. I guess I'm just hung up on the fact that we're talking about somebody's thought process throughout this activity, as opposed to something that, like in a legal malpractice case, where you can look and see what the lawyer did in the case, but as opposed to these transcripts, which are just conversations between an undercover agent and what did the respondent think about during these series of conversations. And I'm looking at this case versus State versus Cobb, which is found at 30 Can App 544, and it said it held that expert testimony regarding a suspect's thought process during an interrogation was inadmissible because the testimony would invade the province of the jury to assess the witness's credibility, which is really what this panel was doing, was assessing the credibility.
Is what you're saying is that our test is not what a reasonable attorney would be thinking in this circumstance, but what this particular person was thinking? So we're not looking at an objective viewpoint, we're looking at the subjective viewpoint? Is that,
what I'm saying
what
is,
was the panel's inquiry? Was it a reasonable attorney inquiry?
I think the panel just heard from him and assessed his credibility and looked at the tapes that were before them. And as Mr. Palmer said, well, really what you're asking us to do, when you're not providing us any of the transcripts, but you have Mr. Foch read the transcripts, and you're going to have him come in here and tell us what Mr. Najim was thinking. And I thought Mr. Palmer said it very eloquently. You give the transcripts to him, you don't give them to us, and you want him to come in and tell you, or tell us, what it is that Mr. Najim was thinking during this process.
I understood your earlier point to be, and you can correct me if I misunderstood, that you don't need a lawyer expressing his or her expert legal opinion to a panel of 3 lawyers. Is that what you're saying?
That's part of it. I mean, when the 3 people on the panel have the same level of expertise as the respondent, and I'm also saying that...
Well, and let me back up for a second. And that goes to the special help language you were talking about earlier. Is that right?
Correct.
And by extension, if you have a legal malpractice case, if it's tried to a jury, the jury presumably would not be all lawyers. But my question to you is, are you aware of legal malpractice cases in which an expert witness testifies to the judge alone?
Your Honor, I am not aware of that. I'm certainly not saying it hasn't happened. I just think it rarely would happen with respect to the thought process.
Okay. And I cut you off. You were about to go someplace else.
Trying to remember where it was I was about to go, but I want to say with respect to this argument, one last thing, because combined with this argument about the expert witness is the respondent's position that the panel relied exclusively on cherry-picked portions of the government's sentencing memorandum. And that's just not correct. I mean, the respondent testified in this case. The panel had the opportunity to observe the testimony, to assess the respondent's credibility, and to listen to his explanation, and to view the various statements that were made that were stated and then transcribed in the government sentencing memorandum. They just didn't believe him from looking at those things. I see where my time's up.
Counselor, can I clarify? We've had
Sure.
a lot of talk about objective, subjective. Your recommendation that the suspension begin on the date of our opinion is premised upon this individual personally, subjectively, knowing that the proceeds, the $16,500 was ill-gotten booty. Personally, not that a reasonable attorney in his situation should have known.
No, that he personally knew, and I think that's what the judge found.
Okay, so we're talking about a subjective, you're asking us to make a subjective determination as to what this person knew.
Right.
Okay.
Based on
All right.
the various groups that made that finding.
And what, is there anything in the record that evidences that, aside from the finding in the criminal case that the panel relied on to shift the burden?
I'm sorry?
Well, if you're asking us to, or your recommendation, as I just understood you in response to Justice Johnson, turns on the respondent's subjective knowledge. And my question is, what in the record evidences that subjective knowledge, aside from the finding in the criminal case? Is there anything?
Well, yes, there is, in my estimation, because if you read the direct examination and cross-examination of the respondent, he was asked to respond to particular portions of recorded conversations. And please explain to me why you responded in this way to Mr. Johnson telling you that I'm engaged in illegal activity, or Mr. Johnson telling you that when you want to come out he invites him out to the warehouse and he's asking for directions, and he said, well, Mr. Johnson said, well, I don't have a sign, what do you want me to put, illegal cigarette activity here? So, I mean, he was asked to respond to each one of these things, and the panel had the chance to observe.
I guess my question is, if the recommendation turns on a fact-finding of subjective state of mind, and if we determine that the panel erroneously shifted the burden onto the respondent, how do we, I guess, what do we make of that? What should we do?
I would back up to, you say erroneously shifted the burden to the respondent.
Yeah, that's an if. I'm saying if
Yeah.
if we disagree with your position with regard to Rule 202.
Yeah, because it clearly was in the panel report. It was identified as an aggravating factor and not a separate finding of misconduct, attorney misconduct.
Any further presentation? Any more questions? Thank you, counsel.
May it please the court, again, I'm Craig Schultz, representing Mr. Najim, who intends, I believe, to speak to your honors at the end of, I guess we need to leave some time for him to do that. This is an intriguing, interesting, and sad case that involves so many different issues. Mr. Najim is an attorney of long standing in Wichita who's enjoyed an impeccable reputation amongst a number of people. Federal judge wrote a letter for him. Karen Humphreys, federal judge, wrote a letter for him. Mike Stout. and so that's the starting place. And then we have this case where he's charged with this in a conspiracy, and this conspiracy involves all kinds of records. Just to give you a glimpse of it, the prosecutor didn't do a Rule 16 disclosure. We asked for one. The magistrate did not require him to do that. Instead, he was allowed to give a document dump to us of, we had to have a 3 terabyte drive to take the documents in. There is an impossible, and I literally mean that, impossible amount of documentation to go through. What we tried to do is isolate it down, tried to go through and take it down to some kind of a sort of a meaningful thing. And Mr. Focht, we talked to him and we asked him, we said, would you look at this? Would you tell us from an objective point of view, is there evidence from which someone can derive a subjective decision? Because subjective, frankly, relies on what the objective facts are. And that is, in this case, what I believe to be one of the most important issues. Mr. Focht, as you know, as you can tell from the scant record that exists, reached the conclusion that there was not sufficient evidence in the tapes from which a lawyer would conclude that there was illegal activity. Now, his opinion was even broader than the issue that was coming before the panel, because we're looking at that. And I would suggest to you that ultimately, I'm not going to get into a lot of detail about it, but ultimately the prosecutor in Western District of Missouri realized, I believe, that he had a real problem, that he had no case against Harry. And so he wanted to come to us and talk to us about making a deal. And we did, rightly or wrongly. We made a deal because Mr. Najim was understandably concerned with what might happen in front of a jury and a judge and all of that. And so, rightly or wrongly, wisely or unwisely, we made a deal to a regulatory infraction, crime, if you will, that said, okay, you know, we had this cash for 15 to 30 minutes in the transfer of that from Wes Williamson, aka Mr. Johnson, gave it to Harry, who gave it actually to his client of some, I'm going to say long-standing, that might be a little misleading, and I don't mean to quantify the time. And that money was given to him because part of it was his. And so, and then Mr. Abood wrote a check for $11,500 for attorney fees. Those fees were deposited, advised to his firm. They were reported. There's no question about any of that. And so, as a practical matter, this whole cash transaction thing was just such a fleeting episode. But it formed the structure, if you will, of a charge to which we ultimately agreed to get resolution on everything, on this thing.
Was Mr. Focht hired as a part of your preparation for the criminal case?
True.
Okay, and so you were utilizing his expertise as a lawyer in this area representing criminal defendants, or what was his, why is he an expert as opposed to anyone else?
Well, because he's done, frankly, a lot of, and he, well, of course, Mr. Focht has impeccable reputation. He has, he's well known. He's done a lot of, I'm going to say, ethics work. He's represented people. This is the first time I've ever gotten to this point representing a lawyer, so it's a little bit of a new thing to me. But he is well-spoken. He's intelligent. He's done criminal defense. He's represented lawyers in disciplinary matters. And we thought he was the excellent choice to take. And so we did the proper disclosures. He looked through everything. And I can't stress enough that there's hundreds and hundreds of hours. These are not easy transcripts where you just sit down and read them or look at them. Some of this is going on for 2 or 3 hours at the Capitol Grill in Kansas City or at some other restaurant. You've got clanging, you've got overtalk, you've got all kinds of things going on. It was a mess. And so we gave it to him, and he arrived at the opinion and was prepared to testify that. What's troubling in this case to me is that we come up for the panel, and I've made a choice. I don't think it's practical on behalf of Mr. Najam to come up armed with transcripts that stack from here to the ceiling or beyond, and to expect the panel to actually fight their way through those. Plus, I believe that the statute made it quite clear that Mr. Foch is capable and qualified as an expert witness. Mr. Hazlitt, I think on the 19th page of the transcript, for whatever it's worth, he even makes the argument, well, you know, if it's in front of a jury, you could use him. You know, the fact finder is the fact finder, and the fact that they have special knowledge, that means if there's a lawyer on my jury, does that mean I can't now use him? That's not what the statute does. So we bring Mr. Foch up to Topeka for the panel hearing. He's sitting there waiting, and they make an objection to him. Without even talking to him at all, they rule that his testimony is not admissible, the panel.
But even if you have an expert that says, maybe a reasonable attorney wouldn't have picked up the red flags, would not have understood this to be proceeds of illegal activity, but this person did know. I mean, that's the issue. Did this person know?
Well,
So just the fact that Mr. Foch says, I wouldn't have known, doesn't negate the fact of whether your client knew or didn't know. And isn't that what we're after here, is what he knew and when he knew it?
well, in part we're after that. I mean, you get into this whole deal, and I apologize, it's a long answer to your question. We get back into the sentencing hearing that they relied on, and the judge cuts us off. And I don't, maybe that's too strong of a word, but when a federal judge looks at you and you go, Mr. Schultz, what is going on here? This makes no difference. It's insignificant. And so we don't cross-examine for a day and a half or 2 days because Mr. Williamson does not enjoy any good credibility or representation. He's had cases dismissed not against him, but where he's done these same kind of things because he's not doing this correctly. But that's the problem. Mr. Foch is not just sitting here saying that he does or doesn't know, because we can't mind read. What he's saying is that you can't cherry pick. I would say you can't unpick the cherry. And he's sitting there looking at the entirety of these transcripts and going through them, and he concludes from that a reasonable lawyer would not, there's not evidence from which you could see that you could make this judgment. So I don't know if I'm going to say something here that's inappropriate. I don't know that this is illegal. I'm frankly convinced that it wasn't. Not because of anything they do, but as I look at this, and a lot of this is timing. This went on from February of 2011, and it goes into way later into the year. And there's a point at which Mr. Najam realizes, but after this transaction took place, where he says, you know what, I don't want to deal with this guy anymore. This guy, there's something going on here. It's strange. Should he have seen something before? I guess we can speculate about that. But Mr. Johnson, Mr. Williamson, whichever way we want to call him, is talking about, he tells him he's got a grease business that makes a lot of money. And bear in mind that what they're paying for in June is not, obviously not for anything afterwards. It's not illegal cigarette sales, because you won't find any place in any of the transcripts. If they'd found it, Mr. Hazlitt could have come up with it. Not any place where Mr. Johnson, Wes Williamson, says, by the way, we're doing illegal cigarette sales.
Well, on that point, Mr. Schultz, from your perspective, what evidence is in the actual record that goes to your client's subjective state of mind or subjective knowledge?
Well, I don't think there's anything that suggests that he knew or should have known.
Well, there's at least a finding by the federal judge, right?
Well, there is, but
And is there anything else from your perspective?
no, there's not anything. Well, I mean, it's you can go back. I've read all these transcripts, and I can look at them and I go, here's what's going on. Again, bear this in mind, if I may ask you to do so. Is that these guys come in They don't come in and say, hey, we've got a bunch of illegal sales going on here. They have nothing like that. Mr. Abood has had a legitimate cigarette brokerage. And he says, we want to do a deal where we import cigarettes, fourth-tier cigarettes from Eastern Europe. We want to bring them into the country. The only thing they say is you want to do it with cash. And there's nothing illegal about cash. Mr. Najm tells him, you got to report the cash, but he says, I will find you a way to do this legally. And he goes, he consults, and he comes up with a plan to do it legally. And lo and behold, they don't want to do it legally, so they scrap the plan. But the payment of fees at that point in time, billed from the firm, is for the work that he'd done in developing this legal plan. Now, later on, things begin to arise. Harry Najm dumps the client. But that's where I think the state of this thing is. It's troublesome to me that Mr. Foch comes up and they want to rely on the civil, it's not a civil judgment, they want to rely on it, they shift the burden. Then the panel not only won't hear, but you can look in the transcript, the panel refuses to let me proffer Mr. Foch, question and answer. Refuses. I had to persuade them, if you will, to accept the letter. And
I'm sorry, counsel, I didn't mean to interrupt. If you want to finish that point.
well, no, that really is my point. I mean, I had to sit there and say, well, at least can I put the letter in so that the court who's going to review this can at least see something? I mean, it would have been interesting. What are they scared of? I didn't know that.
Following up on Mr. Foch's proposed testimony, my understanding, and correct me if I'm wrong, is that he was prepared to testify that I have reviewed the transcripts, which, as you said, are stacked high to the ceiling, or I've listened to the recordings, and based upon what I heard and read, no reasonable lawyer would have believed that these funds were illegal, the result of illegal activity. Am I correct so far?
Yes, basically.
Okay. And it's further my understanding that there was no effort made to put any of that information into the record that Mr. Foch had reviewed. Is that right?
Yeah, Mr. Hazlitt did not put that into the record.
Okay. My question is an expert witness allowed to testify about his or her review of documents or information that are not otherwise in the record?
Absolutely. Happens every case. The statute very specifically says that they can do that.
Okay. And my next question then is, how does the panel determine from this ceiling high stack of documents whether Mr. Foch is accurately testifying as to what they contain? If they don't have those documents or the recordings, are they relying completely upon his testimony that says, yes, they're in there?
Well, subtly, I think you're asking me a question that wants to shift the burden back to me. My position is that we were entitled to bring Mr. Foch in as an expert witness. They get to cross-examine him. The disciplinary administrator can ask him whatever they want. The panel can ask him whatever they want. They want to say, where are the transcripts? Let's continue this, get the transcripts if they don't have them. They have the right to do that.
And so, again, looking at it from the disciplinary administrator standpoint or the panel, if either one of them want to check the accuracy of Mr. Foch's testimony, is it up to them then to pull a document or a transcript out of this ceiling high stack and say, Mr. Foch, that's not what this says? Or do they say, show us in the record where that appears? I'm having trouble understanding mechanically how all that was going to work if that evidence was not in the record.
Well, I can only speak to my experience with expert witnesses. I've done a lot of professional malpractice. I've pursued legal malpractice cases, medical malpractice. The statutes and the law make it very clear, as I understand it, that the expert can even rely on non-admissible evidence. So how does it work in any given case? It's often difficult to say, but generally speaking, the expert can render his opinion if he's qualified. Mr. Foch is well qualified. And if they want to then question his judgment or attack his credibility or whatever, they have the right to do that. And how they would do that, I don't know. That's their choice, not mine. But I don't think subtly that the burden of that explanation ought to fall on Mr. Najum. Is that fair to say it that way?
It is, and I'm not meaning to suggest that the burden shifted. I'm just asking, once you put that evidence in, how do they try to counter that?
Well, and it really, that actually kind of points out the problem is that you can go in and everybody can cherry pick statements out. Well, you can find statements where he said I'm advising you, you've got to report your income, you've got to do this, you've got to do that, you've got to do this. We can cherry pick that, and they could cherry pick out the statements that they think show something. What we were trying to do is contextualize it, if you will, and look at its entire context. You have to go, I don't think this really says this. It looks like something's here, but when you really look at the entirety of a particular conversation, and more importantly, the entirety of all the conversations, you have to go, I don't think it's very clear. Why didn't Mr. Williamson, for example, this is not a secret deal. He knows he's recording himself. And so he comes off the wall with these strange comments right in the midst of a discussion about something else. And he's got in his head, from my perspective, what I believe he's got in his head is something else that he and Mr. Abood know about that they haven't told Mr. Najum. And by the way, they say they're not telling Mr. Najum everything. That's in the transcript. And so they've got, he's got that in his head and he throws it in. Why doesn't he just say, Mr. Najum, we're running illegal cigarettes, and we'd like you to help us legally to do that. And then we would know. Because Mr. Najum, I'm persuaded, I've known Mr. Najum for a long, long time, and I'm persuaded he would have said, get out of here.
Let me address a point that was raised by the disciplinary administrator about a piece of evidence that goes to that issue, I believe, and I'd like your response.
Okay.
I'm looking at, I think it's the plea agreement, which was adopted by the panel. And it talks about on June 21st, 2011, Najum and S.A. Williamson had a telephone conversation arranging to meet later in the week. S.A. Williamson was providing directions to Najum to come to the undercover warehouse. Najum asked if there was a sign on the building, and S.A. Williamson replied, quote, "What are you going to advertise, illegal cigarettes?" unquote. Najum replied, quote, "No, God, don't say that," close quote.
Yeah.
So if you could respond to that.
I can respond pretty simply, I think. Number one, I don't know exactly what was said, but even you, we all do it. You put a voice inflection in there that has an interpretation of some kind of wrongful knowledge. And where's the voice inflection come from? How do we know he didn't say, oh, don't say that. That's, whatever, that kind of an attitude. That's stupid. We don't know what he's saying exactly, okay? But you can't put in an automatic sort of guilty sounding inflection when not a single piece of this transcript was ever listened to by any of them.
So Jack Foch was prepared to testify that he listened to that conversation recording and concluded that no reasonable person, no reasonable lawyer would have believed that these funds arose from an illegal activity. Is that what you're telling me?
I don't think I can truthfully say that because I don't remember what pieces that were listened to versus read or whatever. I'm simply saying that all we have is speculation and innuendo through this thing. And Mr. Hazlitt is trying to do the best job he can. I'm not complaining about it, but I won't even start with him. Paul Becker, who's the prosecutor in this thing, he puts this statement in, and he wants Mr. Williamson to come testify, and they pull out 3 or 4 or 5 kind of statements that, sure, I wish maybe they weren't there, but you can't automatically assume what the context of that statement really was until you look at the entirety of everything.
But the panel had the opportunity to ask Mr. Najum about those particular comments, and they did. They heard his answers to that. Why would we ignore what they concluded based on having heard your client's explanations.
I'm not suggesting that the panel couldn't ask him about something like that, but you're saying then the panel that Mr. Najim, in order to defend himself, can only do whatever the panel asks him. We can't put on the evidence that we think that is quite powerful to the contrary.
I'm asking you that despite the fact that they did that, didn't the panel have what was the best evidence of, which is your client's own explanation?
No.
Why is that?
Because you I guess it's where I'm kind of referring to, it's hard to unpick the cherry. You can't come in and analyze, if there's 10,000 statements, and I'm making up that number, if there's 10,000 statements and they pick out 6 or 5 and go, well, what did you mean by this? And some of these are years before, 5 years ago, 4 years before, 5 years before, I think. And you're trying to figure out what was said and why it was said and what was the context of it. It's not necessarily the best evidence to ask. I have no qualms with the panel asking him. I'm just saying that's not the only evidence that exists. And they didn't, it's baffling to me. Maybe I get incensed about things like this, and whether I should or shouldn't, I don't know. It's baffling to me why the panel wouldn't want to at least hear what Mr. Foch had to say. I mean, that's really troubling. Why wouldn't they even let us proffer it? That's what judges do. You can say, I'm not going to consider that, but if you're going to be the judge on the panel, why would you not want to know when you're talking about taking away somebody's license? And may I, and then Mr. Najim wants to speak very briefly, I believe.
I just have one quick
Okay,
question.
sure.
Do you agree with the disciplinary administrator that all of this that we're talking about goes only to the finding of an aggravating factor as opposed to the rule violation itself?
Let me try to answer, and if I'm not, you tell me. We went in eyes wide open. Mr. Najim, if you plead to this, the disciplinary administrator is going to have to deal with it. It's going to come. Yeah, we understood that.
You understand that he was convicted of a
Yes,
crime, and
yeah.
that by itself
Yeah. Actually,
is
I'm not-
sufficient to make a finding of a rule violation.
Right. With subsequent research, we actually are somewhat convinced that it wasn't really a crime, but we're not going.
That cherry's picked, so to speak, right?
Yeah, we pled to it. We live with that. We have to live with that. Can I comment, and maybe Mr. Haslett can respond? I may be misunderstood about his recommendation, because the recommendation and the findings were not indefinite suspensions. They were 3 years, and I think he said his recommendation was indefinite suspension, and that was not what your recommendation was. So does that make sense?
I understand what you're saying.
Okay.
I just want to make clear, counsel, you've used up your time.
I'm done.
But,
Oh.
you've used up the time that's allocated for the respondent, but because of the nature of this proceeding, what's at stake, I'll allow your client to address this for 2 minutes.
I appreciate it.
All right, thank you.
Can I ask one more question of Mr. Schultz?
Yes.
And that is, I'm sorry if I missed it, but what is your recommendation to the court as to punishment?
Well, we recommended, it's been 2.5 years. I assume there's going to be another couple months or at least before there's an opinion. I mean, clearly we think it should go back retroactively. He's been suspended. He's been honoring that. He's not been practicing law. There's no accusation that he has. We don't want this thing to go remanded back to some new panel or the same panel. That just adds another bunch of time. So our recommendation, I think we asked for a 2-year suspension or something like that, retroactive, which is basically what we would ask for. We're saying kind of enough is enough. Find what you have to
What's the
find.
status of his criminal case and the sanction imposed? Is he on probation currently?
No, he was put on 5 years probation, and then the case was transferred down to Wichita, and Judge Eric Melgren, after 13 months, let him off.
So he is currently has no sanction as a result of the
Done. And the minority
Okay.
panel member was concerned about that. I think that may have gone to why she had a little different recommendation too, but we didn't know that at the time.
So the practical effect of our issuing a decision that said it's going to be effective as the date of his suspension, if it is a 2-year suspension, means that as of the date of our decision, he is under no cloud whatsoever. He's no longer suspended. Is that right?
That was our request. And I think at the time they were asking for a 3-year suspension. If you went on a 3-year suspension, we'd be retroactive, is what we're simply trying to say. That would give it till May, I think, or April, or whatever the date was of next year. What we don't see the point is saying, after 2.5 years, let's just start it when your opinion comes down.
Well, he was suspended, I believe, in May of 2015 from the practice of law in Kansas. Is that correct? And so if we were to release a decision that said our 2-year suspension that you're requesting is retroactive to the date of his temporary suspension, then as of the date the decision came out, he would not be on suspension, correct?
As I understand it, yes.
All right, thank you.
Thank you.
Mr. Najim?
May it please the court. My name is Harry Najim, and as you know, I'm the respondent in this action. I have practiced law in the state of Kansas for 43 years without a single blemish on my record. I never had a disciplinary complaint or malpractice claim or anything. As my counsel said, I believe I am respected by my peers and in the Wichita Bar and the state and federal judges before whom I've appeared. It is the engagement in March of 2011 that has resulted in me standing before you today. I had a long-standing relationship with Jim Abood. He was a tobacco wholesaler who's now deceased. He asked me to help him set up a business to import cigarettes from Eastern Europe. He introduced me to his partner named Johnson, who turned out to be an undercover ATF agent. I later learned during the course of these proceedings that Johnson wore a wire into the first meeting I had with him. They agreed to share the legal fees for my representation, which were to be billed to Mr. Abood's account to my law firm of Adams Jones. Over the next few months, I developed a legal plan for this venture and had discussions with both of them, which were completely legal. They decided not to implement the plan for reasons which I now understand, because Johnson's goal was to make it appear that I was participating in a contrived criminal enterprise. On June 23rd, Johnson gave me $16,500 in cash, which I accepted as an agent for Mr. Abood, and immediately thereafter I gave the funds to Abood, who in turn issued a check to my law firm for $11,500. The fees were paid to the firm and properly reported. I didn't pocket the money. On August 13th, I was indicted on 2 counts of a 44-count indictment. And on February 2015, the 2 counts were dismissed, and I entered a plea to a regulatory infraction of failing to file a currency report. I did not structure a transaction as suggested by Mr. Hazlitt. It was very simply clear I didn't file what could have been at Form 8300, but according to the prosecutor, that couldn't be done because they needed the approval of the Treasury Department. To make a long story short, we later learned that the Treasury regulations exempt reporting requirements for agents. And I was an agent for Abood. Technically, no crime was committed because but I entered that plea because I didn't think I would receive a fair trial. And I did this because I could not compete with the resources of the federal government, having exhausted nearly all of mine. I think the U.S. attorney had been overreaching and abusive. The trial judge refused to consider our claim of government misconduct by a Department of Justice Inspector General report that we presented to the court regarding churning operations of this nature.
Counsel, I hate to interrupt.
2 minutes are up?
Well, they are, but
All right, I'm sorry.
no, I'm just going to say that what
took
you're
all the-
reciting to us is
Yeah.
kind of water under the bridge or over the dam, because you pled guilty to a federal felony. So if we all understand that, and what your reasons were for doing that, I don't think is going to have a bearing on what we're doing today. So I would I would suggest maybe a wiser use of your time is to tell us what, if anything, you want us to do about the fact that you pled guilty to this felony, and then tell us whether you think that then means you have violated one of our rules of discipline. And if so, what discipline should be imposed. That's at least what I'd like to hear from you in your limited time.
All right. Well, I think some of those comments are probably in our brief as well. So, having said that, at the hearing, okay, there's no doubt that I pled. I knew that there would be some proceeding before the disciplinary incident, but I wanted you to know why I did it, okay? I wasn't happy about doing it. I didn't want to do it, but I really didn't have a choice. And let me say this. The judge basically at the sentencing hearing, cut off my counsel's cross-examination, didn't let us put on other evidence, and said it doesn't matter. Well, it did matter. And at the hearing before the Kansas board, the hearing panel embraced the trial judge's findings, and I believe they wrongly concluded that I possessed knowledge based on the opinion of the district judge who made this finding and said it doesn't matter. Well, it mattered then and it matters now because the recommendation of the hearing panel that I remain under suspension for another 3 years is effectively a 6-year suspension. I testified before the hearing panel at length that I had no such knowledge, and I affirm that to this court today. Mr. Hazlitt presented no witness to testify that I possessed actual knowledge, leaving me no witness to cross-examine and no fair opportunity to challenge this false allegation. The hearing panel failed to consider and totally ignored my uncontroverted testimony. Now, my obligation to this court and to all courts is to be truthful as required under Rule 3.3 of the Rules of Professional Conduct. And I can unequivocally state that I had no knowledge that the funds I received were proceeds from an illegal activity, and I did not structure a transaction to evade reporting requirements. The funds in question were to pay my fees for work I did to ensure that the plan that I sought was legal in all respects. I had nothing to do with the presumed illegal sales. And when you read earlier, Your Honor, about me talking on the phone with Mr. Johnson, and I'm asking him where his office is, I said, is there a sign? Because it just gave me a street and a number. He says, yeah, there's a sign that says illegal sales. Yeah, I said, don't say that. I don't want, don't talk that way. I don't know what you're doing, but I don't want, that's not something that you ought to be joking about, Mr. Johnson, okay? But what he was doing was he was setting me up. Now he's got that on a recording. It sounds like I know he's selling cigarettes illegal. I had nothing to do with those transactions. Now, so I had nothing to do with these transactions, and my refusal to acknowledge the wrongful nature of my conduct is consistent with my obligation under Rule 3.3 to the hearing panel to be honest, and they considered that an aggravating factor. I would ask the court and submit that some sufficient discipline has been imposed, having been temporarily suspended 2.5 years ago. I respectfully request that the ongoing suspension be made retroactive to May 15th, 2015, and lifted, that I be reinstated, and that no further discipline be imposed. Yes, indeed, I am deeply saddened that my legal career has come to this. But in hindsight, should I have taken the case? It's really easy to say now, wish I had not. Or perhaps should I have employed greater suspicion? Yeah, I did, but maybe I didn't do enough. Should I have done something I didn't see? Well, even so, I can honestly say this. I had no desire or intent to participate in a criminal enterprise, and if the government had simply asked me to do something illegal, rather than engage in skullduggery and using deceptive, ambiguous comments, and frankly, I wouldn't have done it. I'd have told him, go somewhere else, way below. But frankly, I don't think there's a lawyer or person who knows me who would question that statement. No lawyer, Your Honors, deserves to be set up by the government to fail as I was. I'm not a young lawyer anymore. I'm 69 and still desire to be an active, productive member of the profession that I profoundly respect. I ask that you reinstate me, and I promise you I will not disappoint you. Thank you.
What is the nature of your practice?
It was business litigation.
And that's pretty much
aviation.
your 40-year career is
Over the years,
basically
a lot of
business.
aviation. Yes, sir.
Okay.
Any further questions? All right,
Thank
you,
you for
counsel.
the time. I appreciate it.
Just a couple of things, Your Honor. With respect to my recommendation, I looked at the record. It was indefinite suspension, which is what the panel found in its report. The panel itself did recommend a 3-year suspension with no reinstatement hearing, so there was that difference. Mr. Schultz said it wasn't practical to drop all these pages of transcript on the panel, and I agree with that. Certainly not practical to give that to everybody, but what was practical, when you make the argument that everything's taken out of context, it is certainly practical to put everything into context by at least looking at those portions of the transcript surrounding what appear to be incriminating statements. I want to say that when I looked at the record, Mr. Foch's letter, the way I read the record, was not admitted. The summary letter that Mr. Foch submitted. It is attached to the respondent's brief, and I have no objection to the court considering that. Whether the panel considered it a proffer and it should have been part of the record, I don't believe it was, but I'm here to tell you that I don't object to you considering it.
I'm
And
sorry,
finally, I want
excuse me, counsel, just for clarification, you have no objection to our considering Mr. Foch's letter,
the letter that's attached to the respondent's brief,
which contains his legal opinion?
which would have been his proffer to, I mean, it could have been considered to be the proffer to what Mr. Foch was going to say, obviously. I mean, it's in the record anyway. I mean, Mr. Schultz stood up and said that what he's going to say is that I read all these transcripts and I conclude that a reasonable lawyer would not have known that the money came from unlawful activity. I mean, we all know that. I mean, you just have the letter that says that. Finally, I want to conclude by saying, and Exhibit 10 in the Exhibit 10, my Exhibit 10, is a copy of the transcript of the respondent's sentencing hearing. And when the judge reaches his conclusion about the knowledge that the respondent had, this is what he said in part. And I understand, this is Judge Wimes speaking, and I understand, well, I was walking on the bounds and I'm on the line. Well, some people get too close to the line. If things are sketchy, they are sketchy from the get-go. You know, the evidence I heard with him talking about legal, and I know you were like, I don't want to hear about that, making references to the conversations between the respondent and Mr. Johnson about whether this conduct was legal or not. Well, he is mentioning it, and you have to hear it. At some point, you have an obligation and a responsibility to know. That's what the judge said after he heard the evidence of the transcripts that came in. And you know, you can't, the word cherry picking, I mean, we all know what it means. But when you have the ability to go in and look at those transcripts and to respond in your own sentencing memorandum, just by looking at least at those portions cited by the government, I mean, they had 10 days to respond. I mean, their response to the government sentencing memorandum is also an exhibit. They had the ability to do that. And if you look at the testimony in the transcript, you will see Mr. Schultz saying that really Mr. Najim was not in a state of mind where he could actually look at those transcripts and did not do so. So what they chose to do, rather than putting the portions of the transcripts which might have supported their position, they chose to have Mr. Foch look at everything and get the testimony in that way.
Mr. Hazlitt, can a disciplinary panel use the fact that a respondent defended himself or herself as an aggravating factor?
I'm sorry.
Well, my understanding is that one of the aggravating factors found in this case was that the respondent mounted a vigorous defense.
Nothing wrong with that.
Am I wrong that the panel found that the respondent's denials of the allegations that your office brought was an aggravating factor?
Well, I mean, if they listen to the testimony and they conclude that what the respondent is telling them is not true, then yes.
And wouldn't that always be the case, though? Wouldn't that always be the case if a respondent mounts a defense and the defense is, for whatever reason, not accepted by the panel, that then somehow, I don't understand how that doesn't become a rule that says you can't defend yourself. And if you do, and we don't believe you, that's a double whammy because now we've got an additional aggravating factor.
Well, I see your position, but if the panel listens to the case, listens to the testimony of the respondent, listens to his explanation for those transcribed portions, and they conclude that he's not being honest with them, I mean, I think they have to find that as an aggravating factor. And I don't know that it would apply to every single case, but when the credibility of the respondent is at issue, as it was here, whether or not he knew, and they conclude that he did, as did, you know, the pre-sentence investigator, the judge hearing the case, the prosecutor, this panel, then yes, I think that, at least in this case, should be an aggravating factor.
Any further presentation?
No, sir.
Do we have any more questions? All right, thank you, counsel. We thank all of you for your arguments this morning. Court will take this matter under advisement. This time